Good day, everyone. Welcome again to the Basic Philippine Law and Jurisprudence channel. Our topic for today is jurisdiction. This is again a continuation of the series of lectures on civil procedure. Okay, so we now begin with the definition of jurisdiction. So what is jurisdiction? It is actually the source of the power of the court to hear and decide a case. Okay, remember, the basic thing or the fundamental thing to remember with respect to jurisdiction is that the power and authority of the court to hear and decide a case is conferred by law. It cannot be stipulated by the parties. It cannot be waived. Okay? And it may be raised anytime, even on appeal. Okay? Um, there are different aspects of jurisdiction. First is jurisdiction over the subject matter. Again, this is conferred by law. The authority of the court to hear, try, and decide the case is given by law. Okay? Second is jurisdiction over the parties. The court can acquire jurisdiction over the parties through the service of summons. By the service of summons, the court acquires jurisdiction over the person of the defendant. Third is jurisdiction over the issues. Now, jurisdiction over the issues is conferred by the pleadings. So the issues that you raised in your pleadings will give the court the authority to rule upon those issues. Fourth is jurisdiction over the rest in cases involving property. So, in cases involving in rem actions, okay, jurisdiction over the rest is needed by the court in order to grant it the authority, okay, to subject the property within its power. Okay. The courts obtains jurisdiction over the rest through the seizure of the object under legal process or the institution of legal proceedings. Okay. Now, we first begin with jurisdiction over the subject matter. Okay, the various trial courts as well as the appellate courts and the High Court, the Supreme Court, have their respective authorities, which is given to them by law. Okay, now we will go to each authority of each court one by one. Okay, well, let us go first to the jurisdiction of the first level courts. When we say first level courts, we are speaking of the municipal trial courts, the metropolitan trial courts, the municipal circuit trial courts, and the municipal trial courts in cities. Okay. Under Republic Act 11576, which dated 21 August 2021, the first level courts have jurisdiction over the following cases: exclusive original jurisdiction over civil actions and probate proceedings, whether testate or intestate, including the grant of provisional remedies, where the value of the personal property, estate, or amount of the demand does not exceed 2 million, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs. So the key word here is civil actions as well as probate proceedings. And the threshold amount is it should not exceed 2 million pesos. Okay, so if the subject matter of the action is a civil one or probate, okay, you first determine the amount involved. If the amount of property involved in the civil action does not exceed 2 million, or if the estate, okay, does not exceed 2 million pesos, then you go to the first level court. Okay. The second one is exclusive original jurisdiction over cases of forcible entry and unlawful detainer. So, action interdictal. So, if you have a case for forcible entry and unlawful detainer, regardless of the value of the real property involved, okay, always you should file it with the first level courts. So even if the real property involved is worth 25 million pesos, if your case is forcible entry or unlawful detainer, you don't consider the value of the property, you go to the first level courts because the first level courts have the authority to hear, try, and decide forcible entry and unlawful detainer cases. Okay, third, exclusive original jurisdiction over civil actions which involve title to or possession of real property or any interest therein where the assessed value of the property or interest does not exceed 400,000 pesos. So we now go to actions or civil actions involving title to or possession of real property. So what is the jurisdictional threshold amount? It should not exceed 400,000 pesos. What is that amount? The assessed value. So before the court can determine whether or not it has jurisdiction over an action involving title to or possession of real property, there must be an allegation in the complaint stating the assessed value of the property. Okay, if the assessed value of the property does not exceed 400,000 pesos, then jurisdiction is with the first level courts. If it exceeds 400,000, then jurisdiction is with the second level courts. Okay, so fourth, we have exclusive original jurisdiction in admiralty or maritime actions where the demand or claim does not exceed 2 million. So with respect to admiralty or maritime actions, okay, the threshold amount is that it should not exceed 2 million pesos. So when we say exclusive, what do you mean by exclusive? Exclusive means it is the court which has the authority to exclusively try, hear, and decide these cases to the exclusion of all the other. So that is what is meant by exclusive. Okay, it is the court which has the sole power, okay, to accept these cases, try, hear, and decide them. When we say original, so it means that um, the, the, the case must be filed at the first instance in these courts. Okay? It must be filed originally, okay, at the first instance in this court. So, with respect to the cases which I have mentioned a while ago, civil actions, probate proceedings, in which the property or estate involved does not exceed 2 million pesos, forcible entry and unlawful detainer, civil actions involving title to or possession of real property, the assessed value of which does not exceed 400,000 pesos, and admiralty or maritime actions where the demand or claim does not exceed 2 million pesos, the exclusive and original jurisdiction of which are conferred to the first level courts. Municipal trial courts, municipal circuit trial courts, metropolitan trial courts, municipal trial court in cities. Okay, we now go to the jurisdiction of second level courts. What do you mean by second level courts? When we speak of second level courts, we are speaking of regional trial courts. Okay, now what is the jurisdiction of regional trial courts? Okay, first, all civil actions in which the subject of the litigation is incapable of pecuniary estimation. Okay, so the primary object of the action is not capable of pecuniary estimation. So in these cases, these belong exclusively to the jurisdiction of the RTCs. Second, all civil actions which involve title to or possession of real property, the assessed value of which exceeds 400,000 pesos. So, as we have discussed a while ago, if the assessed value of the property is less than 400,000 pesos, you go to the first level. But if it is 400,000 pesos or more, okay, then you go to the second level, the regional trial. Third, all actions in admiralty and maritime jurisdiction where the demand or claim exceeds 2 million pesos. A jurisdiction of which is with the RTC. Fourth, in all matters of probate, testate, and intestate, where the gross value of the estate exceeds 2 million pesos. Okay, in all other cases in which the demand exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and cost or the value of the property in controversy exceeds 2 million pesos. So in other words, in all other cases or civil actions in which the value of the property or the demand exceeds 2 million pesos. And lastly, original concurrent jurisdiction to issue writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and auxiliary writs or processes. Okay. So the thing that you have to remember with respect to the jurisdiction of the second level courts is that, okay, if forcible entry or unlawful detainer is endemic to first level courts, actions which are incapable of pecuniary estimation is endemic on second level courts, meaning it is the sole court which can exclusively try here and decide these cases. All actions involving title to or possession of real property, the assessed value of which exceeds 400,000 pesos. What if the real property involved has an exact assessed value of 400,000 pesos, which court has jurisdiction over that action? The answer is it is the first level courts. You must remember that the jurisdiction of second level courts only refers to those where the assessed value of the property exceeds 400,000 pesos. So if the assessed value of the property is 400,001 peso, that falls with the jurisdiction of the RTC. Okay, admiralty, maritime jurisdiction, for where the demand or claim exceeds 2 million. Probate matters, where the gross value of the estate exceeds 2 million. All other cases in which the value of the property exceeds 2 million. And writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto. Remember that with respect to these writs, okay, the jurisdiction of second level courts is concurrent. When you say concurrent, there are other courts which also have jurisdiction over the issuance of the said writs or processes. We now go to the jurisdiction of family courts. Family courts are specialized courts, okay, which has jurisdiction over the following cases: petitions for guardianship, custody of children, and habeas corpus in relation to minors. Okay, petitions for the adoption of children. Although now, adoption is no longer within the jurisdiction of family courts. It is now with the National Institute for Child Care, okay, which is under the Department of Social Work. Okay. Complaints for annulment of marriage, declaration of nullity of marriage, and those relating to marital status and property relations of husband and wife, petitions for support or acknowledgement of children, summary judicial proceedings brought under the provisions of the Family Code, petitions for declaration of children as abandoned, dependent, or neglected children, petitions for voluntary or involuntary commitment of children, suspension, termination, or restoration of parental authority, petitions for the constitution of family home. In criminal cases, the family courts also have jurisdiction over cases where the accused is a minor or where the private complainant is also a minor. Cases for violation of Republic Act 9262 or Republic Act 7610. Okay, so in all of these cases, it is the family court which has jurisdiction. Okay, we now go to the jurisdiction of the Court of Appeals, which is an appellate court and not a trial court. Okay, first, the Court of Appeals have original jurisdiction to issue writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and other auxiliary writs or processes. It also has exclusive original jurisdiction over actions for annulment of judgment of RTCs. So if you want to annul the judgment of the regional trial court, you go to the Court of Appeals. Exclusive appellate jurisdiction over all final judgments, decisions, resolutions, orders, awards of RTCs, family courts, and quasi-judicial agencies, including the SEC, SSS, ECC, and the Civil Service Commission, except those falling within the appellate jurisdiction of the Supreme Court in accordance with the Constitution as well as the Labor Code. And fourth, appeals from the RTCs on constitutional, tax, jurisdictional questions involving questions of fact or mixed questions of fact and law. Okay. We now go to the jurisdiction of the Supreme Court. First, the Supreme Court, the highest court of the land, has original and concurrent jurisdiction to issue writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and other auxiliary writs or processes, petitions for the issuance of writ of amparo, writ of habeas data, and writ of kalikasan, appeals from the CA, Sandigan Bayan, and Court of Tax Appeals, actions affecting ambassadors and other public ministers and consuls, special civil actions under Rule 65 on judgment, final orders, or resolutions of the COA as well as the COMELEC, appeals from judgments or final orders of the RTC exercising original jurisdiction in the following: all cases involving the constitutionality or validity of any treaty, international or executive agreement, presidential decree, proclamation, order, instruction, ordinance, or regulation, all cases involving the legality of any tax, imposed assessment or toll, or any penalty imposed in relation thereto, and all cases in which the jurisdiction of any lower court is in issue, all cases in which only an error or question of law is involved. Okay, we now go to the case of Denila versus Republic. In this case, the Supreme Court defined the different aspects of jurisdiction. Of course, we all know that jurisdiction is the power and authority conferred by the Constitution or by law to a court to hear and decide a case. It has several aspects. jurisdiction over the subject matter, over the parties, over the issues, and over the rest. Okay. Jurisdiction over the subject matter, as we have previously discussed, is conferred by law. Okay. Jurisdiction over the parties is the power of the court to make decisions that are binding on the parties. It is conferred by the service of summons, valid service of summons. Jurisdiction over the issues is the tribunal's power, okay, to decide over matters which are either disputed by the parties or simply under consideration. It may be conferred by either express or implied consent of the parties. Jurisdiction over the rest pertains to the court's authority over the object or thing subject of the litigation, as well as its power to bind the said property. Jurisdiction over the remedy pertains to the authority of a tribunal to take cognizance and pass upon the propriety of petitioner or complainant's relief sought. Okay, so what we have here in the case of Denila, okay, is one for reconstitution of title. This case has one definite party who petitions or applies for a declaration of a status right or a particular fact, but there is no definite adverse party. So the authority to proceed is conferred by statute, which is the compliance to the jurisdictional requirements of the petition. Reconstitution of title is a special proceeding. Being a special proceeding, it must allege and prove certain jurisdictional facts before the trial court can acquire jurisdiction. Okay. We have the case of Esmendi versus Fernandez. Okay, the rule is settled that a court's jurisdiction over the subject matter is determined by the relevant allegations in the complaint. So we now come to the question of how do you determine whether a case is one which is a civil action involving title to or possession of real property, or one which is incapable of pecuniary estimation. Okay, you determine that by inspecting or examining the allegations in the complaint. Okay, the law in effect at the time when the action was filed and the character, the relief sought. So you first examine the complaint or the petition as well as the principal relief sought. You can determine the kind of action or the nature of the action by determining or discovering the principal relief sought by the plaintiff. Okay. Salvador versus Patricia. Jurisdiction over real action is based on the allegations of the complaint. So with respect to real actions involving title to or possession of real property, it is always very important to allege in the complaint the assessed value of the real property involved. Why? Because without that allegation on the assessed value of the real property, the court will not be able to determine whether it has jurisdiction over the said action. You must remember that under the law, okay, if the real property, assessed value of the real property is 400,000 or less, the jurisdiction is with the first level courts. But if it exceeds 400,000, then jurisdiction is with the second level courts. Now, how will the court know whether or not it has jurisdiction over the said action involving title to or possession of real property if, okay, the assessed value is not alleged in the complaint? So the silence of the complaint on such value is a ground to dismiss the action for lack of jurisdiction. Jurisdiction is a matter of substantive law because it is conferred only by law, as distinguished from venue, which is only a procedural matter. It cannot be conferred by the agreement of the parties or by the court's acquiescence or by the erroneous belief of the court that it had jurisdiction or by the waiver of objections or by the silence of the parties. You must remember that jurisdiction is conferred by law. It cannot be stipulated upon, it cannot be waived, and it can be raised at any stage of the proceedings. The test for determining jurisdiction is ordinarily done in the nature of the case as made by the complaint and the relief sought, and the primary and essential nature of the suit, not its incidental character. Jurisdiction may be classified into original and appellate, the former being the power to take judicial cognizance of a case instituted for the first time under conditions provided by law. The appellate jurisdiction, on the other hand, is the authority of a court of a higher rank to re-examine the final order or judgment of a lower court that tried the case elevated for judicial review. Also, you must distinguish jurisdiction from the exercise of jurisdiction. It does not mean that if the court which exercised jurisdiction made a wrong judgment, it divests him of jurisdiction over the case. Jurisdiction is different from the exercise. The test of jurisdiction is whether or not the court had the power to enter on the inquiry, not whether or not its conclusions were correct. For the power to decide necessarily carries with it the power to decide wrongly as well as right. In this case of Salvador, the complaint of the petitioners did not contain any averment of the assessed value. Such failure left the trial court of any basis to determine which court could validly take cognizance of the cause of action for quieting of title. We now move to the case of Boston Equity Resources versus Court of Appeals. This is a case involving a complaint for a sum of money. However, at the time of the filing of the complaint, the husband and co-defendant Manuel is already dead. So, in this case, it was undisputed that when Boston filed the complaint, Manuel was already dead. Such being the case, the court could not have acquired jurisdiction over the person of Manuel because he no longer has the personality to become a defendant in a case. So jurisdiction over his person was not obtained. So the aspect of jurisdiction which may be barred from being assailed as a result of Estoppel by laches is jurisdiction over the subject matter. Since the defense of lack of jurisdiction over the party is not one of those defenses which are not deemed waived, such defense must be invoked when an answer or a motion to dismiss is filed in order to prevent a waiver of the defense. Okay, so you must remember that when there is a defect regarding jurisdiction over the person of the defendant, you must raise it. Okay, otherwise, it can be waived. What cannot be waived is jurisdiction over the subject matter. Jurisdiction over the person of the defendant is acquired through service of summons. Precisely because he was already dead even before the complaint against him was filed, he cannot be validly served with summons. The court's failure to acquire jurisdiction over one's person is a defense which is personal to the person claiming it. Failure to serve summons on Sereno's person will not be a cause for the dismissal of the complaint, considering that they have been served with copies of the summons and complaints. Okay? So we now move to the case of Aala versus Uy. Aala versus Uy talks about the hierarchy of courts. So when you file a case, okay, can you file, for example, a case for breach of contract directly with the Supreme Court? Of course, the answer is no. Or no, not breach of contract. Let us say petitions for certiorari. Okay. Petitions for certiorari, jurisdiction is concurrent um, between and among the RTC, the Court of Appeals, and the Supreme Court. But with respect to petitions for certiorari, can you file it directly with the CA or the SC? For example, Aala versus Uy tells us that parties must comply with the doctrine of hierarchy of courts and exhaustion administrative remedies. Otherwise, they run the risk of bringing premature cases before this court, which may result to protracted litigation and overclogging of dockets. The doctrine of hierarchy of courts is a practical judicial policy designed to restrain parties from directly resorting to this court. When you say court supreme, means Supreme Court, when relief may be obtained before the lower courts to prevent the congestion of court dockets. The doctrine of hierarchy of courts is determinative of the appropriate venue where petitions for extraordinary writ should be filed. Parties cannot randomly select the court or forum to which their actions will be directed. Trial courts do not only determine the facts from the evaluation of the evidence presented before them, they are likewise competent to determine issues of law which may include the validity of an ordinance, statute, or even an executive issuance. The Court of Appeals is primarily designed as an appellate court that reviews the determination of facts and law made by the trial court. It is collegiate in nature. This nature ensures more standpoints in the review of the actions of the trial, and their writs can have a nationwide scope. This court will not entertain direct resort to it when relief can be given in the lower courts. This holds especially true when questions of facts are raised. Trial courts and the Court of Appeals are better equipped to resolve questions of facts. They are in the best position to deal with causes in the first instance. Because you see, class, when we speak of trial courts, the word trial implies reception of evidence. So if there are factual issues, okay, you first go to the trial courts, okay, which can receive the evidence in a trial. Okay. On the other hand, the appellate courts, Court of Appeals, as well as the Supreme Court, they are designed to review the decisions of the trial courts. They're not designed to receive evidence. Okay? That's the reason why they are collegiate in nature, precisely for the purpose of reviewing if there are errors that are committed by the trial courts in receiving the evidence as well as in applying law and jurisprudence to the facts. Okay. However, there are certain exceptions to the doctrine of hierarchy of courts, and they are as follows. When genuine issues of constitutionality are raised, when the case involves transcendental importance, when the case is novel, when the time is of the essence, when the subject of review involves acts of a constitutional organ or branch of the government, when the petition includes questions that may affect public welfare. So in these cases, okay, you can file the case directly with the High Court, but it is incumbent upon the petitioner to prove or demonstrate before the High Court that they belong to any of the exceptions for which direct resort can be justified. Okay. Let us now go to the case of First Sarmiento Property Holdings versus PBCO. Okay. First Sarmiento tells us or provides us guidelines in order to determine the kind of action that is involved. Okay, you have to determine the kind of action that is involved because the kind of action will determine the jurisdiction, which court has jurisdiction to try the action. For example, if it is an action involving title to or possession of real property, then the jurisdictional amount or the basic um, information that you will look for in the complaint is the assessed value of the real property involved. Okay? If it is all other civil actions, okay, then you have to determine the um, amount of claim, amount of damages. If it is an action involving which is not capable of pecuniary estimation, then there is no jurisdictional amount that is involved because it, as the name implies, it's not capable of pecuniary estimation. Now, how do you classify or how do you determine the kind of action that is involved in a complaint? Okay, the Supreme Court tells us to determine the nature of an action, whether or not it is capable or incapable of pecuniary estimation. The nature of the principal action or relief sought must be ascertained. So you examine the complaint, you look for the nature of the principal action or relief. Okay, if the principal relief is for the recovery of a sum of money or real property, then the action is capable of pecuniary estimation. However, if the principal relief is not for the recovery of sum of money or real property, even if a claim over a sum of money or real properties results as a consequence of the principal relief, the action is incapable of pecuniary estimation. So what is involved in this case? PBCom filed a petition for extrajudicial foreclosure of real estate mortgage. Now, the clerk of court refused to accept the complaint in the absence of the tax declarations, which would be the basis for determining the assessment of docket fees. First, Sarmiento claimed that it never received the loan proceeds from PBCom, yet the latter still seeks to foreclose the real estate mortgage. PBCom asserted that the RTC failed to acquire jurisdiction over First Sarmiento's complaint because the action for annulment of mortgage was a real action. Thus, the filing fee should have been based on the fair market value of the mortgage properties. Now, how do you determine what kind of action is a complaint for annulment of real estate mortgage? Jurisdiction to determine whether the subject matter of an action is incapable of pecuniary estimation, the nature of the principal action or remedy must first be established. If it is primarily for the recovery of a sum of money, the claim is considered capable of pecuniary estimation. However, where the basic issue is something other than the right to recover a sum of money, or where the money claim is purely incidental to or a consequence of the principal relief sought, like in suits to have the defendant perform is part of the contract and in actions for support, for annulment of judgment, or to foreclose a mortgage, this court has considered such actions as cases where the subject of the litigation may not be estimated and are cognizable exclusively by the RTC. Here, the primary relief prayed for is the cancellation, the real estate and chattel mortgages for want of consideration. This court ruled that where the issue involves the validity of a mortgage, the action is one which is not capable of pecuniary estimation. Okay, because they are assailing, in the case of First Sarmiento, the validity of the mortgage itself. Okay, we now move to the case of Philippine-Japan, active carbon versus Borghini. So in this case, Philippine-Japan leased an apartment from Borghini. Now, the petitioner, Philippine-Japan, deposited an amount as security deposit. Now, when the lease expired, Philippine-Japan asked for the return of the security deposit. Borghini, on the other hand, refused to return. As a result thereof, petitioner filed an action for collection of a sum of money equivalent to the amount of the security deposit. Okay. The issue is whether the MTCC has jurisdiction over the complaint. Okay. A reading of the complaint makes out a case for collection of sum of money and not for breach of contract. It is to be noted that the lease agreement has already expired when the petitioner asked for the return of his deposit. Since it had already expired, there is no more contract to breach. So it is clearly one for collection and not for breach of contract. Heirs of Ramiro versus Bacaron. In this case, the petitioners argued that the main thrust of the complaint was to recover the property. Yet, the Bacaron failed to allege its assessed value. Thus, the petitioners asserted that the RTC did not acquire jurisdiction over the subject matter. When the main relief sought is specific performance, the action is incapable of pecuniary estimation, which is within the exclusive jurisdiction of the second-level courts. When the action, on the other hand, primarily involves Title II or possession of land, the court which has exclusive jurisdiction is determined by the assessed value of the property. Pauses Bacaron countered that the case records show that the main relief prayed for is one for declaration of the validity and effectivity of the deed of sale and specific performance, or that the petitioners be ordered to execute the deed of conveyance and transfer of the property. However, the Supreme Court said the ultimate relief sought by the respondent is for the recovery of the property through the enforcement of a sale in their favor. When a complaint is entitled as one for specific performance, but nonetheless prays for the issuance of a deed of sale, its primary objective is to recover the parcel of land and is thus deemed a real action. So in other words, it is not the title of the complaint that is important. It is the principal relief sought, which can be discovered from the body of the allegations in the complaint as well as in the prayer thereof. So the court which has jurisdiction is determined by the assessed value of the property. And without an allegation in the complaint of the assessed value, it cannot be determined which court has jurisdiction over the same. We have the case of Roldan versus Barrios. So in this case, Roldan filed an action for foreclosure of real estate mortgage. Now, the petitioner argued that foreclosure of real estate mortgage is an action incapable of pecuniary estimation and jurisdiction lies with the regional trial court. To determine whether a court has jurisdiction over the subject matter, it is important to determine the nature of the cause of action and the relief sought. An action involving Title II real property means that the plaintiff's action is based on his claim that he owns the property and he has the legal right to have exclusive control, possession, and enjoyment of the same. So in case of foreclosure of mortgage, the allegation showed that the loan obtained by Barrios fell due and they failed to pay, which was secured by a mortgage on the property, and that in case of default, the property will answer for the obligation. Foreclosure is but a necessary consequence of non-payment of the mortgage indebtedness. Therefore, the foreclosure suit is a real action insofar as it is against property and seeks the judicial recognition of a property debt and an order for the sale of the rest. So it is an action involving title to or possession of real property. We now move to the case of Iniego versus Purganan. Okay, this is a case involving a complaint for quasi-delict and damages. How do you classify a case for quasi-delict and damages? Is it one involving collection of sum of money, an action which is capable of pecuniary estimation, or is it one which is incapable of pecuniary estimation? Okay. The trial court holds the view that the main cause of action is not the claim for damages, quasi-delict. Damages are being claimed only as a result of fault or negligence of the defendants. But since fault or negligence could not be the subject of pecuniary estimation, this court has exclusive jurisdiction. However, the Supreme Court said that actions for damages based on quasi-delicts are primarily actions for the recovery of a sum of money. Okay? For the damages suffered because of the defendant's tortious acts and is therefore capable of pecuniary estimation. What must be determined to be capable or incapable of pecuniary estimation is not the cause of action, but the subject matter of the action. The subject matter of the action is the physical facts, the thing real or personal, the money, lands, chattel, and the like, in relation to which the suit is prosecuted, and not the delict or wrong committed by the defendant. So the criterion to ascertain the nature of the principal action or the remedy sought, if it is primarily to recover sum of money, the claim is capable of pecuniary estimation. Actions for damages based on quasi-delicts are primarily one, for the recovery of sum of money, for the damages suffered because of the defendant's tortious acts. In sum, actions for damages based on quasi-delicts are actions that are capable of pecuniary estimation, and thus they fall within the jurisdiction of either the RTC or the MTC, depending on the amount of damages claimed. Okay, we now go to the case of Pantranco North Express versus Standard Insurance. So this is a case involving a vehicular mishap, okay, wherein Crispin was driving the jeepney owned by his mother Martina. Okay, it was then raining. While driving northbound along a highway, a passenger bus owned by Pantranco was trailing behind. When the two vehicles were negotiating a curve along the highway, the passenger bus took over the jeepney. In so doing, the passenger bus hit the left rear side of the jeepney and sped away. Now, Crispin reported the incident and respondent standard insurer of the jeepney. So the total cost of the repair, the amount of which was 21,000, but standard paid only 8,000. So the owner of the jeep shouldered the balance of 13,000. Now Standard and Martina demanded reimbursement from Pantranco. They refused. So this prompted the respondents to file a complaint with the RTC for a sum of money. Both petitioners deny the allegations and they contend that it is the first level, not the RTC, which has jurisdiction. The issue of whether respondents' claims shall be lumped together is determined by the totality rule. When there are several claims or causes of actions between the same or different parties embodied in the same complaint, the amount of the demand shall be the totality of the claims in all the causes of action. So the claim of Martina as well as the claim of Standard will be added up to determine which court has jurisdiction over the action. Okay. Respondent's cause of action arose out of the same transaction. Thus, the amount of the demand shall be the totality of all the claims. Okay. We now move to the case of Fausto versus Multi-Agri Forest. So in this case, Lilith and Jonathan, in separate transactions, obtained several loans from Agri Forest. When they defaulted in the payment of their loans, several complaints were filed. Now, the petitioners contended that it was the first level which has jurisdiction over the case and not the regional trial court. The Supreme Court said the totality rule does not apply in this case. The totality of claims rule applies only when there are several claims or causes of action between the same or different parties embodied in the same complaint, in which the total amount shall be the determinative of which court has jurisdiction. However, it does not call for the application of the rule since there are 5 complaints, each pertaining to a distinct and separate claim not exceeding 200,000. The petitioners act of lumping together the amount of the claims and arguing that the total amount exceeds the jurisdictional amount of the first level is a gross misinterpretation of the provision. Okay, we now move to the case of Tiham versus Sibong Hanoi. Okay, beforehand, we learned that jurisdiction is over the subject matter is conferred by law and it cannot be stipulated by the parties or it cannot be waived. Okay, now can Estoppel, can laches, okay, apply to jurisdiction? Okay, in the case of Tiham versus Sibong Hanoi, okay, 1 month after the effectivity of Republic Act 296, the spouses Tiham commenced a civil case in the RTC against Sibong Hanoi to recover from them a sum of money. So a writ of attachment was issued by the court against the properties of the defendant, but the same was dissolved upon the filing of a counter bond by Manila Surety. Now, after trial, the court rendered judgment in favor of the plaintiff, and after the same had already become final and executory, the court issued a writ of execution against the defendants. The writ having been returned unsatisfied, the plaintiffs moved for the issuance of writ of execution against the surety bond. Now, the surety appealed to the Court of Appeals. Okay. Not one of the assignment of errors raises the question of lack of jurisdiction. So the CA decided the case, affirming the order's appeal from. Instead of filing a motion for reconsideration, the surety filed a pleading entitled Motion to Dismiss, alleging substantially that appellee's action was filed in the RTC of Cebu, uh, and that at that time, the Republic Act 926 was already effective, which placed the jurisdiction over the said action not with the RTC but with the MTC. It is an undisputed fact that an action commenced by the appellees in the CFI against Sibong Hanoy was for the recovery of sum of money, an amount within the original exclusive jurisdiction of the first level courts. Okay. True also is the rule that jurisdiction over the subject matter is conferred by law, and the objection may be raised at any stage of the proceedings. We are of the opinion that the surety is now barred by laches from invoking this plea at this late hour for the purpose of annulling everything done in the case with its active participation. A party may be estopped or barred from raising a question in different ways and for different reasons. We speak of estoppel in pais or estoppel by deed or by record, and of estoppel by laches. So you must remember the case of Tiham is more of the exception rather than the rule. The general rule is that jurisdiction is conferred by law. It may not be waived. It cannot be stipulated by the parties. However, in this case, the jurisdiction issue was raised only when the judgment was already final and executory, and it was already being executed. Okay, so the surety was given the opportunity to participate in the proceedings, and yet it did not question or raise the issue of jurisdiction. Laches is negligence or omission to assert a right within a reasonable time, warranting a presumption that the party entitled to assert it has either abandoned it or declined to assert it. It has been held that a party cannot invoke the jurisdiction of a court to secure affirmative relief against his opponent, and after obtaining or failing to obtain such relief, repudiate or question that same jurisdiction. After voluntarily submitting a cause and encountering an adverse decision on the merits, it is too late for the loser to question the jurisdiction or power of the court. It was only after an adverse decision was rendered by the CA that it finally woke up to raise the question of jurisdiction. Okay, we now move to the case of Figueroa versus People. This is a case involving reckless imprudence resulting to homicide, which was filed before the regional trial. So there was a judgment convicting the petitioner, which was questioned on the ground of the lack of jurisdiction of the RTC. Okay. When is a litigant estopped by laches from assailing the jurisdiction of a tribunal? Does the fact that the petitioner failed to raise the issue of jurisdiction during the trial amount? Does the active participation of the petitioner in the trial of the case amount to estoppel? So the Supreme Court said in the case of Figueroa, the ruling in Sibong Hanoy on the matter of jurisdiction is the exception rather than the rule. Estoppel by laches may be invoked to bar the issue of lack of jurisdiction only in cases in which the factual milieu is analogous to that in the cited case. In such controversies, laches should be clearly present. Indeed, the general rule remains A court's lack of jurisdiction may be raised at any stage of the proceedings, even on appeal. The reason is that jurisdiction is conferred by law, and the lack of it affects the very authority of the court to take cognizance of and to render judgment on the action. In Sibong Hanoy, the defense of lack of jurisdiction was raised for the first time in a motion to dismiss filed by the surety almost 15 years after the questioned ruling had been rendered. It was only when the adverse decision was rendered by the CA that it finally woke up to raise the question of jurisdiction. So for Sibong Hanoy to apply, the lack of jurisdiction must have been raised so belatedly as to warrant a presumption that the party entitled to assert it had abandoned or declined to assert it. In this case, however, the petitioner is not estopped by laches, considering that he raised the lack thereof in his appeal before the appellate court. No considerable period had yet elapsed for laches to attach. Delay alone, though unreasonable, will not sustain the defense of estoppel by laches unless it appears that the party, knowing his rights, had not sought to enforce them. The court considered the patent and revolting inequity and unfairness of having the judgment creditors go up their calvary once more after more or less 15 years. So the doctrine must be applied with great care, and equity must be strong in its favor. When misapplied, the doctrine of estoppel may be a most effective weapon for the accomplishment of injustice. We now move to the case of Kalimlim versus Ramirez. So in this case, Kalimlim, administrator of the estate of the deceased, upon learning that Domingo's title over a parcel of land was cancelled, filed a petition for cancellation of title to real property. Okay. The court, however, dismissed the petition for lack of merit on the basis only of a memoranda of the parties. The petitioners did not appeal. 2.5 years after the dismissal, petitioner filed another case, praying for the cancellation of the conveyances and sales that were made with respect to the subject realty. Okay. Private respondent moved for dismissal on the ground of res judicata. The court held that the defense of res judicata does not obtain to bar the second suit. The judgment rendered by the RTC in the first case was null and void because when sitting as a land registration court, it had no jurisdiction to pass upon controversial issues involving ownership of title to real property. Okay. Jurisdiction of a court over the subject matter of the action is a matter of law and may not be conferred by consent or agreement of the parties. The lack of jurisdiction of a court may be raised at any stage of the proceedings. The exceptional circumstance involved in Sibong Hanoy, which justified the departure from the accepted concept of non-waivability of objection to jurisdiction, has been ignored, and instead a blanket doctrine had been repeatedly upheld that rendered the supposed ruling in Sibong Hanoy not as the exception, but rather the general rule, virtually overthrowing altogether the time-honored principle that the issue of jurisdiction is not lost by waiver or estoppel. In this case, the petitioners may not be faulted with laches. Title to the property owned by them had erroneously and illegally been cancelled and registered in the name of another entity who had no right to the same. Thus, they filed a petition to cancel that title. It is even a possibility that such dismissal was in view of the realization of the respondent court not sitting as a cadastral court it lacked the authority to entertain the petition involving, as it does, a highly controversial issue. So you must remember that the ruling in Sibong Hanoy involving Estoppel by Laches on the issue of jurisdiction is more of the exception rather than the rule. So all the factual milieu in Sibong Hanoy must be present in the case for it to be applied. Okay? Absent the said factual milieu, Sibong Hanoy cannot be applied. It is neither fair nor legal to bind a party by the result of a suit which was taken cognizance of in a court which lacks jurisdiction over the same. Okay, the duty of the court when it has no jurisdiction is to dismiss an action. Should the court render a judgment without jurisdiction, such judgment may be impeached or annulled for lack of jurisdiction. We now move to the case of Cabrera versus Clarin. This is a case involving action publicana with damages. There is a motion to dismiss where the respondents claim that the complaint failed to state the assessed value of the property. Now, the issue is whether or not Estoppel bars the respondents from raising the issue of lack of jurisdiction. The nature of an action and the jurisdiction of a tribunal are determined by the material allegations of the complaint and the law at the time that the action was commenced. The operation of the principle of estoppel on the question of jurisdiction depends upon whether the lower court actually had jurisdiction or not. If the lower court had jurisdiction, and the case was heard and decided upon a given theory, such as that the court had no jurisdiction, the party who induced it to adopt such theory will not be permitted on appeal to assume an inconsistent position that the lower court had jurisdiction. Here, the principle of estoppel applies. So, jurisdiction by estoppel. This court rules that respondents are not estopped from assailing the jurisdiction of the RTC over the civil case. Records reveal that even before the filing of their answer, respondents assailed the jurisdiction of the RTC through a motion to dismiss, as there was no mention of the assessed value of the property. As the assessed value is a jurisdictional requirement, the belated presentation of a document proving such value will not cure the glaring defect in the complaint. Thus, jurisdiction was not acquired. The case of Mangaliag versus Pastoral. The case of Mangaliag versus Pastoral. So in this case, Cerquina filed before the Regional Trial Court a complaint based on quasi-delicate. On the other hand, petitioners filed their answer and a motion to dismiss on the ground of lack of jurisdiction over the subject matter, alleging that it is the municipal trial court which had jurisdiction over the case. In an action for recovery of damages, does the amount of actual damages paid for in the complaint provide the sole test for determining the court's jurisdiction? Or is it the total amount of all the damages, regardless of the kind and nature, such as moral, exemplary, nominal, etc.? They seasonably presented the objection to the RTC's lack of jurisdiction during the trial stage. Hence, finding the pivotal element of laches to be absent, the Sibong Hanoy doctrine does not apply. Instead, the general rule that the question of jurisdiction of a court may be raised at any stage of the proceedings must apply. Hence, the demand for moral damages must be considered as a separate cause of action, independent of the claim for actual damages, as must be included in determining the jurisdictional amount. If the rule were otherwise, the court's jurisdiction in a case of quasi-delict causing physical injuries it would only be based on the claim for actual damages and the complaint is filed in the MTC, it can only award moral damages in an amount within its jurisdictional limit, situation not intended by the framers of the law. Rianella versus Banayad. So this case involves the allowance of the holographic will of the decedent. Okay. The RTC of Pasay, according to the Supreme Court, had no jurisdiction over the subject matter in that case. Jurisdiction of the court to hear and decide the case is conferred by law, as well as the allegations in the petition. Nowhere in the petition is there a statement of the gross value of the estate. From a reading of the original petition filed, it cannot be determined which court has original and exclusive jurisdiction over the proceedings. So you must remember, class, that if you're dealing with civil actions involving title to or possession of real property, the assessed value of the real property involved must be alleged in the complaint. If in cases of settlement of estate, probate, whether testate or intestate, settlement of estate, okay, there is also a necessity to allege in the complaint the gross value of the estate, without which the court will not be able to determine if it has jurisdiction over the case. Why? Because with respect to settlement of estates, the gross value of the estate is determinative of the court which has jurisdiction. If it exceeds 2 million pesos, then jurisdiction lies with the RTC. If it is 2 million or less, jurisdiction lies with the MTC. Hence, the trial court's assumption of unauthorized jurisdiction over the probate has been discovered by the court during the appeal stage of the main case, not during the execution stage of a final and executory decision. Hence, Sibong Hanoy will not apply. We have the case of Duero versus Court of Appeals. Eradel entered and occupied petitioner's land. Petitioner filed a complaint for recovery of possession and ownership with damages. Okay, private respondent alleged that the RTC had no jurisdiction since the value of the land was below the jurisdictional threshold and therefore should be with the first level court. Was the private respondent estopped from questioning the jurisdiction of the RTC? In this case, we are in agreement with the CA that he was not. For Estoppel to apply, the action giving rise thereto must be unequivocal and intentional. Because if misapplied, Estoppel may become a tool for injustice. Recall that it was petitioner who filed the complaint against private respondent and two other parties before the said court, believing that the RTC had jurisdiction over his complaint. But by then, Republic Act 7691 became effective, such that jurisdiction already belongs not to the RTC but to the MTC pursuant to the said amendment. In his MR, he raised for the first time the RTC's lack of jurisdiction. His motion was denied. Note that the private respondent raised the issue for lack of jurisdiction not when the case was already on appeal, but when the case was still before the RTC that ruled him in default, denied his motion for new trial as well as for relief from judgment. The fundamental rule is that the lack of jurisdiction of the court over an action cannot be waived by the parties or even cured by silence, acquiescence, or even by express consent. Further, a party may assail the jurisdiction of the court over the action at any stage of the proceedings, even on appeal. When a party commits error in filing his suit in a court that lacks jurisdiction, such act may not at once be deemed sufficient basis for estoppel. It could have been the result of an honest mistake or of divergent interpretations of doubtful legal provisions. Under the rules, it is the duty of the court to dismiss an action whenever it appears that the court has no jurisdiction over the subject matter. Okay, now compare the case of Duero with the case of Velasquez versus Lisondra Lang. So in this case, Velasquez entered into a joint venture agreement to develop a parcel of land into a memorial park. Now, due to several anomalies, Perfecto filed a complaint against Lisondra for breach of contract before the regional trial court. Lisondra moved for dismissal on the ground that according to Lisondra, it is HLURB that has exclusive jurisdiction. Okay, now, Perfecto filed another complaint before the HLURB. Now, the HLURB ruled in favor of Perfecto. Lisondra appealed. The HLURB dismissed the case for lack of jurisdiction. According to the HLURB, it is the RTC that has jurisdiction over the case. Okay. The CA dismissed Perfecto's complaint, clarifying that the HLURB's authority is limited only to cases filed by the buyers or owners of subdivision lots and condominium units. So in other words, it's not the HLURB but the RTC. Perfecto argued that Lisondra land is now estopped from assailing the HLURB's jurisdiction. Is not allowed to make a complete mockery of the judicial system, resulting in two conflicting appellate court decisions. If it had no jurisdiction, but the case was tried and decided upon the theory that it had jurisdiction, the parties are not barred on appeal from assailing such jurisdiction, for the same must exist as a matter of law and may not be conferred by consent of the parties or by estoppel. However, if the lower court had jurisdiction and the case was heard and decided upon a given theory such that the court had no jurisdiction, the party who induced it to adopt such theory will not be permitted on appeal to assume an inconsistent position that the lower court had jurisdiction. Here, the principle of estoppel applies. That estoppel shall not apply when the court or tribunal has no jurisdiction over the subject matter. We rule that the present case is an exception and calls for the application of jurisdiction by estoppel. In this case, Perfecto originally filed this complaint against Lisondra before the RTC, which has jurisdiction over the case. However, Lisondra claimed that the case is within HLURB's exclusive authority. Perfecto relied on the final and executory decision of the appellate court and they filed the case with HLURB. Lisondra actively participated in the proceedings before the HLURB. After receiving an adverse decision, Lisondra questioned the jurisdiction of the HLURB and claimed that the RTC has the authority to hear the case. This is where estoppel operates and bars Lisondra from assailing the HLURB's jurisdiction. We now move to jurisdiction over the parties and over the case. Jurisdiction over the person of the plaintiff is acquired upon the filing of the complaint, while jurisdiction over the person of the defendant is acquired through service of summons. The court acquires jurisdiction over the case through the payment of the docket fees. In permissive counterclaims, okay, there is also a need to pay the corresponding docket fee for the court to acquire jurisdiction over the permissive counterclaims. Okay. What is the rule on failure to pay the docket fees? Failure to pay the docket fees within the reglementary period allows only discretionary but not automatic dismissal. The power should be used by the court exercising its sound discretion in accordance with the tenets of justice and fair play. Manchester Development Corporation versus Court of Appeal. A case is deemed filed only upon payment of the docket fee regardless of the actual date of filing in court. Okay, all complaints, petitions, answers, and other similar pleadings should specify the amount of damages being paid for, not only in the body but also in the prayer, because it will be considered in the assessment of docket fees. So again, the court will acquire jurisdiction over the case only by the payment of the correct docket fees. Okay, Bungkayaw versus Fort Ilocandia. This is an action for declaration of nullity of contract. Okay, petitioner alleged that his son had no authority to represent him and that the deed was void and not binding upon him. The only issue raised by the petitioner was his claim for damages, while respondent's issue was only his claim for possession. Whether respondent's counterclaim is compulsory. Okay. Respondent filed 3 counterclaims. The first was for the recovery of the 400,000. Second was recovery of possession. Third was for damages. Respondent's second counterclaim is only a permissive. It is not a compulsory counterclaim. It is capable of proceeding independently of the main case. The rule in permissive counterclaim is that for the trial court to acquire jurisdiction over it, docket fees must be paid. In this case, respondent did not dispute the non-payment of docket fees. Respondent only insisted that its claims were all compulsory counterclaims. So what happens if the court rules that it is only a permissive counterclaim and the docket fees were not paid, then the court will not acquire jurisdiction over the case. Okay, as such, judgment by the trial court in relation to the second counterclaim is null and void without prejudice to a separate action which may be filed by the respondent against the petition. We have the case of Sun Insurance versus Asuncion. Private respondent filed a complaint with the RTC for the refund of premiums. The complaint did not quantify the amount of damages, so only the amount of 210 was paid by the respondent as docket fee, which prompted the petitioner to raise an objection. So 7 months after filing the supplemental complaint, the respondent paid the additional docket fee of 80,000 plus. So not having paid the same, the petitioners contend that the complaint should be dismissed. Okay. In the case of Sun Insurance, the Supreme Court made a more liberal interpretation regarding the non-payment of docket fees. A more liberal interpretation is called for, considering that unlike Manchester, respondent demonstrated his willingness to abide by the rules by paying the additional docket fees. The promulgation of the decision in Manchester must have had that sobering influence on the respondent who thus paid the additional docket fee. It triggered his change for stance by manifesting his willingness to pay additional docket fee as may be ordered. So the Sun Insurance assured these rules relative to the payment of docket fees, where the filing of the initiatory pleading is not accompanied by payment of docket fee. The court may allow payment of the fee within a reasonable time, but in no case beyond the applicable prescriptive or reglementary period. The same rule applies to permissive counterclaims, third-party claims, and similar pleadings, which shall not be considered filed until and unless the filing fee is paid. When the trial court acquires jurisdiction over a claim by the filing of the appropriate pleading and payment of the prescribed filing fee, but subsequently the judgment awards a claim not specified in the pleading, or if specified, the same has been left for determination by the court, the additional filing fee shall constitute a lien on the judgment. We have the case of United Overseas Bank versus Ross. In this case, respondent filed an action for damages, accounting, and the release of the loan and machinery. Now, the respondent failed to specify the amount of damages either in the body or the prayer to evade the payment of docket fees. In cases where the parties do not deliberately intend to defraud the court in the payment of docket fees and manifest its willingness to pay additional docket fees, the liberal doctrine enunciated in Sun will apply, meaning to give him a period of time to comply by the uh, paying additional docket fees. This case should not be dismissed but be allowed to continue, and that the private respondent's unpaid docket fee should be considered as a lien on any judgment in its favor. Negros Oriental Planters versus Judge RTC 52. This is a complaint for breach of contract with damages. In this case, Campos deliberately concealed the exact amount of actual damages by opting to estimate the value of the unwithdrawn molasses in order to escape payment of the docket fees. In case where the party does not deliberately intend to defraud the court in the payment of docket fees and manifests willingness to abide by the rules, then the doctrine in Sun Insurance will apply, since the circumstances clearly show that there was no deliberate intent to defraud the court. The case of Sun should be applied. Camaso versus TSM Shipping. In this case, Camaso was found suffering from tonsillar cancer. Respondent refused to shoulder Camaso's medical expenses, thus forcing the latter to pay for his treatment. The CA dismissed Camaso's petition for non-payment of docket fees, where the filing of the initiatory pleading is not accompanied by payment of docket fees. The court may allow payment of the fee within a reasonable time. The court deems it appropriate to relax the technical rules in the interest of substantial justice and hence remands the case to the CA for resolution in the merit. General versus Clarabal. And this is a case for libel. Now, the court enunciated the rule that when the amount of damages other than the actual is alleged in the complaint or information, then the corresponding filing fee shall be paid by the offended party. Now, when the amount of damages is not alleged in the information, the corresponding filing fees need not be paid and shall simply constitute a lien on the judgment. So if the amount of because in criminal cases, di ba, the civil action is impliedly instituted with the criminal action. Now, if there is an amount of damages claimed by the private complainant, then the clerk of court should assess and collect the amount of docket fees for the civil aspect. However, if there is no amount that is alleged in the information and later on in the judgment, there is an amount of damages awarded to the complainant, then docket fees will correspondingly be assessed and paid. Manuel versus Alpeche. This is also a case for libel. It was alleged that Manuel suffered actual moral and exemplary damages in the amount of 10 million. Okay, we hold that the said general ruling, the last sub-paragraph was actually intended to apply to a situation wherein either the judgment awards a claim not specified in the pleading or the complainant expressly claims moral, exemplary, temperate nominal damages but does not specify any amount at all, leaving the quantification thereof entirely to the trial court's discretion and not to a situation where the litigant specifies some amounts for the awards being sought, even though the different types of damages sought be not separately or individually quantified. Okay. Okay. We now go to the doctrine of primary jurisdiction. What does the doctrine of primary jurisdiction mean? Courts will not resolve a controversy involving a question which is within the jurisdiction of an administrative tribunal, especially when the question demands the exercise of sound administrative discretion, requiring the special knowledge, experience, and services of the administrative tribunal to determine technical and intricate matters. So, the doctrine of primary jurisdiction, okay, is invoked not to defeat resort to judicial adjudication, but to rely on the expertise and specialized knowledge of administrative agencies. Paloma versus Mora. In this case, Paloma was appointed as general manager but was subsequently terminated. Now, the petitioner filed a petition for mandamus before the RTC to contest Paloma's dismissal. Respondents moved to dismiss on the ground of lack of jurisdiction. Now, whether or not the Civil Service Commission has primary jurisdiction over the case for illegal dismissal of the petitioner. Okay, the Supreme Court said courts cannot and will not resolve a controversy involving a question which is within the jurisdiction of an administrative tribunal, especially where the question demands the exercise of sound administrative discretion requiring special knowledge, experience, and services of the administrative tribunal. Quasi-judicial bodies like the civil service are better equipped in handling cases involving the employment status of employees as those in the civil service since it is within the field of their expertise. Industrial Enterprises versus Court of Appeals. In a judgment, the trial court ordered the rescission of the Memorandum of Agreement and declared the efficacy of the coal operating contract and ordered the reversion of the two coal blocks. Now, the issue is whether or not the civil court or the trial court has jurisdiction to hear and decide the suits for the rescission of the MOA concerning coal operating contracts. Now, in the memorandum agreement sought to be rescinded, it is derived from coal operating contracts and is tied up with the right to develop coal-bearing lands and the determination of whether or not the reversion of the coal operating contract over the coal blocks would be in line with the integrated national program for coal development and with the objective of rationalizing the country's overall coal supply demand. IEI's cause of action was not merely the rescission of a contract, but the reversion or return to it of the operation of the coal blocks. Considering that the jurisdiction to pass upon any question involving the MOA revolving as it does around a coal operating contract should be sustained, the doctrine of primary jurisdiction finds application, since the question of what coal areas should be exploited and which entity should be granted coal operating contracts involves a technical determination by the BEP. So it is not a mere simple case of rescission of contracts, because in determining whether or not the contract should be rescinded, okay, there is a need to determine whether the coal operating contracts should be canceled. Okay? And the cancellation of the said coal operating contracts is determined by the technical expertise of the BED, because it would have to consult the entire coal operating plan of the government. So it lies on the technical expertise of an administrative agency. Tumaudos versus San Miguel Yakamura. So in this case, petitioner became an employee of San Miguel. Petitioner availed of its separation program, but San Miguel withheld the amount of 1.4 million on behalf of the cooperative, to which it had an indebtedness. Now, petitioner filed a complaint before the NLRC for non-payment of separation pay, claiming that he has already paid his indebtedness to the cooperative. So it becomes apparent that the controversy involves a debtor-creditor relations between the petitioner and the cooperative, rather than an employer-employee relations between San Miguel and the petitioner. Evidently, the employer-employee relationship is merely incidental, and the principal relief sought can be resolved not by reference to the labor code, but by the general civil law. So where the principal relief sought is to be resolved not with reference to the labor code, but by the general civil law, jurisdiction over the dispute belongs to the regular courts and not to the NLRC. We now go to equity jurisdiction. Equity is the principle by which substantial justice may be attained in cases where the prescribed or customary forms of ordinary law are inadequate. So equity fills the void in the law. Okay, it aims to provide complete justice in cases where a court of law is unable to adapt its judgments to the special circumstances of a case. The purpose of equity jurisdiction is to prevent unjust enrichment and to ensure restitution. Reyes versus Lim. Okay, petitioner filed a complaint for annulment of contract. Lim learned that Reyes had already sold the property to another buyer. Lim sought the cancellation of the contract to sell and requested that Reyes be ordered to deposit the 10 million down payment with the trial court, which was granted by the latter. Reyes points out that deposit is not among the provisional remedies allowed under our procedural rules. However, there is a hiatus in the law, and if left alone, the hiatus will result in unjust enrichment to Reyes at the expense of Lim. Now, this calls for the application of equity jurisdiction. Reyes is seeking rescission of the contract to sell. Lim is also seeking the cancellation of the contract to sell. The trial court ordered Reyes to deposit the 10 million down payment that Lim made. Reyes admits receipt of the 10 million down payment but opposes the order to deposit the amount in court. Reyes contends that prior to a judgment annulling the contract to sell, he has the right to use and possess the 10 million. Since Reyes is demanding to rescind the contract to sell, he cannot refuse to deposit the 10 million down payment. Such deposit will ensure restitution of the 10 million to its rightful owner. Lim has nothing to refund as he has not received anything under the contract to sell. In this case, it was just and equitable and proper for the trial court to order the deposit of the 10 million down payment to prevent unjust enrichment by Reyes at the expense of Lim. We now move to the case of Durban Apartments versus Katakwi. So in this case, petitioner City Garden hired Katakutan as front office manager. Makaslev accused him of immorality and dismissed him from the service without furnishing him with a copy of the report and the charges filed against him. So, respondent, Katakutan, filed a complaint for illegal dismissal and non-payment of wages. However, in the exercise of its equity jurisdiction, the court may disregard procedural lapses so that a case may be resolved on the merits. The dismissal of cases purely on technical grounds is frowned upon. So indeed, the rules of procedures are merely tools to expedite the resolution of cases. Okay. How do you distinguish jurisdiction from exercise of jurisdiction? Jurisdiction is the authority to decide the case, while the decision and not the decision rendered therein. When there is jurisdiction over the person and the subject matter, the decision on all the other questions arising on the case is but an exercise of jurisdiction. The errors which the court may commit in the exercise of jurisdiction are merely errors of judgment, which are the proper subject of an appeal. Thornton versus Thornton. So in this case, petitioner is an American and the respondent is a Filipino. They were married. However, after 3 years, they separated. And then the wife, okay, took the child and went to Lamitan, Basilan. Now, the petitioner filed a petition for habeas corpus in Makati City, but this was dismissed because the child was not in Makati, but in Basilan. So he filed another petition for habeas corpus, this time in the Court of Appeals. Now, the issue in this case is whether the Court of Appeals has jurisdiction to issue writs of habeas corpus in cases involving custody of minors in the light of the provisions of RA 8369 giving family courts exclusive original jurisdiction over such petitions. In other words, he went to the Court of Appeals instead of the the family court. Individuals who do not know the whereabouts of minors they are looking for would be helpless, since they cannot seek redress from the family courts whose writs are enforceable only in their respective territorial jurisdiction. We rule, therefore, that RA 8369 did not divest the CA and the Supreme Court of their jurisdiction over habeas corpus cases involving custody of minors. So because with respect to writs issued by the trial courts, it is only enforceable within their respective territorial jurisdiction. Unlike in the writs issued by the Court of Appeals, it is enforceable nationwide, so in the entire country. So if you do not know the place where the child is being kept, it is best to um, apply the writ before the CA, which writs are enforceable anywhere in the Philippines. So that's it for jurisdiction. Thank you for listening and don't forget to subscribe.